SJC-11878, Commonwealth versus Navarro.
Good morning.
Good morning. May it please the court. Elizabeth Billowitz for the defendant appellant Santiago Navarro. This case is here on further appellate review. Mr. Navarro is appealing his convictions arising out of the robbery of a poker game. There were 10 victims in the case. 2 of them tentatively picked out Navarro from a non-blind photo array. I'd like to start by addressing specifically what instructions were given, what instructions were not given, and how those omitted instructions would have made a difference in this case. And I'd then like to talk about the importance or non-importance of the absence of counsel request for those instructions, both in this case and in going forward. So what Mr. Navarro received from the trial judge was effectively the introductory paragraph to the model Rodriguez instruction that was in place at the time. The judge told the jury that ID was an important issue. The judge explained reasonable doubt in the context of ID. And the judge gave a Presley honest mistake instruction. All of those were absolutely correct. I'm sorry?
So that wasn't asked for. Judge Wilkins
That's
just
correct.
gave it.
Defense counsel asked for no specific ID instructions in this case. The court also, much earlier in the charge, about 12 pages earlier in the transcript, gave a general witness credibility instruction, which actually is, I believe, the final paragraph of the model Rodriguez instruction. It's something that the trial judge is supposed to reiterate after giving all of the specific factors. So this court stated in Johnson that the purpose of ID instructions is threefold: to emphasize their importance, to inform of the burden of proof, and to furnish the criteria by which the jury can assess the quality of the identification. The judge here covered the first 2 bases adequately. The judge did not touch the specific factors.
How was it argued to the jury by counsel?
The counsel argued that the witnesses were inconsistent among themselves as to how they described the suspect, and counsel did emphasize heavily that the eyewitnesses would not have had a good view of the suspect because he was almost completely masked. And the panel below incorrectly relied on the fact that counsel argued these issues in closing argument to say this was adequately covered. I would submit that counsel argument is absolutely no substitute for judicial instruction that would have gone over the specific factors that would have been rendered with judicial authority. The fact that counsel did focus on this means that the issue was before the jury. It was adequately raised.
Can you help me understand how the judge was in error when, as I understand it, Rodriguez was not required at that time, nor was it requested. So where's the error here?
Well, it is debatable whether Rodriguez was considered a required instruction. However, that's beside the point for our purposes because we're still here under a substantial risk of miscarriage review.
You mean whether it was error or whether it was ineffective assistance of counsel not to ask for it, it's the same thing. You end up at the same place.
You end up in the same place. And so again, the panel erred here in saying there's no error because there was no request. And my brief has cited numerous cases explaining that this is simply reviewed for substantial risk of miscarriage of justice when there's the omission of an ID instruction where it was unrequested, unpreserved, we still end up in the same place. And I think, obviously going forward, the issue of a counsel request is incredibly important, and I can get to that now, or I can get to that later.
Let me just ask you this. How is it that this defendant should end up in a better position than the defendant in Gomes? I mean, Gomes did not get the benefit of the rule. So basically, you're saying we should change the rule and we should apply it to this defendant, but that didn't happen in the Gomes case. So how is this defendant in any better position than the defendant in Gomes?
These are in two different postures. Gomes was asking for a new instruction. All Mr. Navarro should have received was the model instruction that was in place at the time. I'm not arguing that Gomes should have been retroactive to this case. That's not what's presented here. It was uncontroverted that the Rodriguez model instruction, as modified by a few subsequent cases, was what should have been instructed where ID was an issue. And so you see that some of the cases below say, if ID is an issue, instruct it. There's also some that use language that say upon request. The cases that say upon request, I think each are distinguishable for various reasons. Most of them actually pertain to Presley, which is quite a different thing. I mean, Presley...
But Presley is part of what you give in Rodriguez, so it makes me a little uncomfortable, your argument that the judge in this case completely abdicated any responsibility to instruct on ID. That's just not the case.
Presley distills and summarizes one theme of Rodriguez. And so it makes complete sense in a case where Rodriguez was properly instructed. If you don't mention Presley, that's not typically going to be prejudicial. And that's what the panel said here. The inverse is absolutely not true, because Rodriguez mentions a whole host of other factors that have nothing to do, or that at least are much more specific than this kind of broad theme of honest mistake that's expressed in Presley.
If you could develop that point, because your brother says, okay, let's assume you're right, that it was, that the attorney was ineffective in failing to ask for an instruction that he was otherwise entitled to, but if you look carefully at what he would have gotten in the context of this case, in view of the other evidence, one can't say it would have mattered. So would you address his view that if you look at the Rodriguez instruction,
Sure.
on this evidence, it turns out not to be really something that would have had consequence?
Okay. The first Rodriguez factor concerns the witness capacity and opportunity to observe. Obviously, that was a key issue here, given that the suspects were masked, the stress of the situation, and also the fact that the suspects were unknown to the eyewitnesses. And that last one in particular, I think, is the sort of non-obvious factor, something that the jurors wouldn't necessarily have thought about in assessing their reliability.
But didn't two of the witnesses identify the defendant as being among the robbers? And I take it this was after they left the building, after they left the card game. Was there evidence that they had taken off their masks?
No.
So what was the basis of the identification?
At least one of them said the eyes. That was it. And all of the only point on which all of the witnesses were consistent in their descriptions was that just a very narrow band of this person's face was visible. They couldn't agree on clothing, skin color, really anything else.
Well, he showed up in a car at the police station that had the same description of the car, same license plate as the robbers drove off from the scene in.
That's correct. So the next day, Mr. Navarro accompanies his girlfriend to the police station. I would submit that this is not particularly potent evidence, given how unlikely it seems that the participant in what seemed like a very professional robbery is then going to show up at the police station the next day.
Yeah, but he was charged with committing a crime. He wasn't charged with being stupid.
That is true, and what you're describing is actually very significant in understanding how the IDs in this case may have been influenced,
But
likely unintentionally, by the police in this case.
But what about, I mean, well, this isn't, you need to get back to the Rodriguez factors, but it does seem to me you've got this, the Shorty, who's, you know, who obviously knows the defendant. And I know you say, well, yes, but he's a very tainted witness. But if we're talking about substantial risk, is there really a substantial risk?
Well, it's more than the fact that Shorty's credibility was questionable here. I think it's very unlikely that the jury would have returned a conviction solely based on Shorty, not just because of his credibility issues, but there was nothing else corroborating.
The phone records.
The phone records didn't have Navarro's name on them. The only thing that
Well, I know,
connected
but
them,
it certainly has Milagros's calls going back to the same number.
right? But it didn't have Navarro's name. There was nothing. Shorty never testified that he knew Raw's real name. No one else testified that Navarro and Raw were the same person. Again, nothing put his name on the phone records.
Did Shorty identify your client at trial?
He did, and this was
Raw?
also as Raw, but this is procedurally irregular as well. It came out at trial kind of unexpectedly that Shorty had looked at an array, again given by the same detective in a non-blind procedure after Navarro had come to his attention by coming in with his girlfriend. And the trial judge said that he would suppress the in-court ID because there was no witness report produced by the police. That issue kind of ended up getting submerged, but the Commonwealth has since represented that there was no report made of that ID procedure of Shorty identifying.
I thought what the judge said was, I will suppress it. I will strike it if there was a report that wasn't disclosed. That's
Right,
different
right.
than there not being a report.
Oh, well, it's since come out that there was
I know,
no
but
report. It's one more irregularity in the ID procedures. And I agree, in a normal case, when you have a cooperating witness who is familiar with the defendant, this might not be such a concern. But here, I think there are very real concerns about the way, the chain of events, the link of this detective between all of the IDs and the non-blind procedures. And this court has certainly recognized that the blindness or non-blindness of a photo array is an extremely important factor, and that actually leads back to one of the other Rodriguez factors that was not given here, whether the eyewitness IDs were influenced. Again, this is important because of the absence of double blind. This is not the kind of thing that the jury would have known on its own to pay attention to in considering the reliability of the
Did that come
IDs.
up in cross-examination? The non-double blind, all those factors, the Silva-Santiago factors?
Yes, no, it definitely did come out. There was absolutely a factual basis for giving that instruction. And another aspect of Rodriguez that was not given was the failed or inconsistent IDs. And this is important here because of the inconsistencies in one of the two witnesses, Legere. He said to the detective during the array that his certainty was 80%. At trial, he's saying it's 100%. Again, this is not an issue that would be obvious to jurors. The role of witness certainty, this court has observed, is counterintuitive.
But is that part of Rodriguez that it's counterintuitive, or Gomes?
Not specifically that it's counterintuitive. And I want to make clear, Gomes would have been
Well, I
far
understand, but I'm
better
just trying to
here,
see,
but
did that one really make a difference in this case?
I think the omission of all of these factors, and including the fourth one of the lapse of time in between the crime and the ID. I think all of
5 days?
it was 3 days in case of the it was 3.5, looks like, in case of the poker players, and about 8 days in terms of Shorty. So considering all of those factors together, weighed against this less than overwhelming backdrop, there was no confession here, no physical evidence. There's no reason to think that the jury would have convicted Mr. Navarro had it been properly instructed as to the Rodriguez factors. I haven't even made it to what I think are very important issues going forward as to.
Thank God for your brief. So,
Thank you.
Thank you.
May it please the court, Kenneth Steinfield for the Commonwealth. I'd like to begin with a general principle. I disagree with my sister that it is debatable that the state of the law at the time of trial was that a request for a Rodriguez instruction was not required. I think the law is clear that in the absence of a request, it was not error for a judge not to give a Rodriguez
But
instruction.
isn't she right, though? You get to the same place?
Absolutely.
Okay.
But I'm just talking doctrinally. The analysis that the court should have engaged in was counsel ineffective, which this court has said many, many times, is basically two sides of the same coin. It's the same thing. But just to be consistent doctrinally, when there's no request, there was no error. But I agree, you get to the same place eventually.
Can I ask you this? Going forward, what do you think the rule should be? Assuming that that's correct, that no request, no error, going forward?
Well, I don't think there's any reason to change it. I think the system
Really?
now currently works, that if there is a prejudicial failure to give a Rodriguez
But
instruction.
I mean, given what we know about eyewitness, you don't think that maybe it should just be, if it's an issue, a contested issue in the case, the judge should, whether requested or not, should give it?
That was the first part of my answer, that I don't think it's necessary. However, at the same time, I don't think that I can make a principled argument that it should not be given in every case.
Well, was there any benefit to the defendant in this case from an instruction not having been given?
Yes, there certainly was. I think that, as the appeals court found and as I argued, there was good reason why several of the instructions which were not given and not asked for might very well have adversely affected the defendant. And that includes the lapse of time instruction. It's only 3 days. Some people might say, well, that's no time at all. Then it was fresh in their memory. So if a jury is told you should take into account the lapse of time, that might, to the jurors, say, wow, this was right away. More so, the instruction that you should take into account the circumstances under which the ID was made. This is 30 to 40 minutes in
But
a
they've
room.
got masks on. I mean, how do you make an ID when all you're looking at is the eyes and you don't know the person?
Well, 4 people were not able to, and 2
But I mean, the
did.
2 that did, but I mean, really, if I've got a, I mean,
Right,
unless they are wall-eyed or cross-eyed, I just don't, it just seems to me not terribly persuasive that I pick somebody out when all I can see is the eyes and I've never met this person in my life.
Well, that is a subject for a closing argument. That was hammered home repeatedly, the difficulty of making an ID
Well,
based
that's
on
why
those
the instruction
circumstances.
would have been helpful.
Which one?
Well, the first one, the first Rodriguez factor,
Well, they did get that one as part of
back in the
the general
general
credibility.
witness.
But this court in Franklin, and there's an appeals court case called Evans, where they said that that was satisfactory. It did apply to all witnesses, but it did tell them to take into account their capacity, their ability to recollect the events that they
But there was
saw.
anything about the timing, the physical proximity, the lighting, the past familiarity? Did they get any of those instructions?
I'm sorry, I thought it was a question about evidence and then
We're
instruction.
talking about that the circumstances of the crime would not have helped the defendant.
May not have helped.
But the fact that they had on masks, the fact that you said all of these things were argued, but they were argued by the defendant without
Sure.
the court guiding them, that these factors actually do matter.
Yes, that's correct. They do matter.
They
All
were
I'm
given
saying
no
is that it's-
instruction, they were given no instruction that they do matter.
Well, but they were told generally in the credibility instruction to take into account the capacity of the person to observe what he was then testifying about. And that was a general instruction that was as applicable to the eyewitness IDs as opposed to any other testimony.
I mean, it's a certain level of common sense here. If someone's masked, it's certainly harder to identify him, and that can certainly be brought out in cross-examination, which I'm sure it was endlessly here.
Yes, I don't think that
You
it's
don't need a court to say, oh, by the way, if they're masked,
You do
it may be
not need-
harder to do this.
I agree completely. You do not need a judge to tell them that. That is plain both from human experience and common sense and from the arguments of counsel. There's a lot of the Rodriguez instructions that I think are based on common sense. I think it's very different with the Gomez instructions, a lot of which are counterintuitive. But as to Rodriguez, many of them are just common sense, like a failure of a witness to make an ID. The jury doesn't have to be told, well, that's important, that he didn't identify him. So things like that,
Now, in this case, though, you didn't have that.
that's right. That's right. But nonetheless,
You had a bunch of witnesses who couldn't make an ID, didn't you?
right. But the Rodriguez instructions go to witnesses who make positive IDs.
At trial.
No witness who made a positive
Oh, I see what you're
ID
saying.
at trial made a failed or an inconsistent.
Right, sorry.
Right. So that's,
Now, I have your argument that there was something in Rodriguez which may have been adverse can always be said. I mean, of course, you mentioned a whole set of things, and there's always going to be something that's not going to favor the defendant. But if that's to be the criteria, then we almost never would find that a defendant would be, or defense counsel would be ineffective for failing to give it.
well, I think that it would be more difficult, but not impossible. There are some of the instructions that are more focused than the ones that were not given here. If there were no Presley at all in a very, very Presley-esque case, that I could see that counsel might have no plausible reason for not having, for having to fail to ask. And I think there are cases that have held that the failure to ask for a Presley, which is, as has been said, the thrust of Rodriguez, might constitute ineffective assistance and or a substantial risk. But the other ones, like the ones that my sister claimed should have been given here, I don't think fall into that category. I don't think that the difference, that the outcome of the trial would have been any different at all if the judge had given the 4 instructions that she says that he should have, which were never asked for.
Now, am I correct that it may have been different if we had Gomes at this time? That the consequence of the failure to give may be more severe because it's not necessarily common sense instructions.
Yes, I think that is the great divide that separates Gomez from the prior regime is the fact that most of those are counterintuitive, and most of the Rodriguez, I really think, are common sense. They're important, no doubt about it, but they have a much larger common sense factor than the Gomez ones, which this court has found, and I can't disagree with, that a lot of the Gomez instructions, an ordinary juror would not only not believe it, but would believe the opposite.
How about the failure to follow the protocols of Silva Santiago here?
Well, the Rodriguez instruction says only that you should take into account the circumstances under which the identifications were made, period. It does not give any further detail. You should ask yourself whether this was a series of pictures. It doesn't get into any detail at all. So the failure of the judge to instruct, that had no effect in this case because it was so general. The Rodriguez does not talk at all about the specifics of what are those
Yes,
circumstances.
but that, if there had been a lot of questions in the cross-examination, which there were, it would have played on that. I mean, in other words, a jury could have understood the general instruction in that context.
Absolutely.
But it wasn't given, so,
Right, but the defense, there was no doubt at trial what the issues were. And I think that the defense counsel did a very, very capable job here of placing before the jury very forcefully, very rationally, he painstakingly went over with every witness. There were 7 of the 10 victims testified. And the key is, was a defense, a major defense, submerged by the lack of the instructions?
with respect to the, putting that aside, with
Yes.
respect to the Shorty and the telephone records, just taking the telephone records first.
Sure.
I take it that what you have is, you don't, it's not, nothing identifies it as Mr. Santiago's telephone, and we don't know in whose name it was, correct?
That is correct.
But we do know that, or I take it, that Shorty said, that's my number that's appearing on this
Right.
whole thing.
Right, so he ID'd his own phone records.
And what he thought was the ones coming from Santiago. And then it's the same bill that has also Milagros
Right.
Hernandez, right?
That's what ties it together, as well as the fact that on Shorty's cell phone, he had a contact information. He knew the defendant as Raw or Raw Diggity, which he testified to, and it said on the cell phone, which was in evidence, that if you clicked on Raw, that number came up. So I think that there was ample evidence before the jury that those phone records were those of Santiago Navarro, Milagros Fernandez, and of Shorty. And I think that those records are devastating. And I apologize for putting them into my supplemental record appendix. I know how tedious they are, page after page of numbers. But if you look at them, the phone calls, the fact that they align perfectly with Shorty's recitation of events. When he got busted, he didn't want to go to jail, and he wanted to minimize, no doubt. But everything he said, from who got into the car and who sat where, to the phone calls and the texts, were all corroborated by evidence that he didn't even know existed. So Shorty and the phone records, I think, basically, if you had no identification testimony, if neither Gary nor Joel had been able to say, I believe 8 out of 10, because of the difficulty, and they got it right based on all of the other evidence. I'll start again. If you didn't have that ID evidence, this is still an overwhelming case that this defendant was the gunman. The jury came back in less than 3 hours, and although that's always sort of problematic, how do you judge how soon they can say, well, maybe they were so swayed by the identification evidence, but I think here that it makes sense that there was so much evidence that was marshaled by the prosecutor in his closing, and I won't go over it as to why there was overwhelming evidence of guilt independent of those IDs.
Now, of those who did not identify him from the photo spread, did they identify anybody else?
No. One said that he believed that he had, one testified that he believed he had selected 3 or 4 as maybes, but the detective said he had not identified anybody. And so the defense counsel was able to exploit that. But the detective said that only Gary and Joel were able to identify anybody, and that the other 4 people who were shown the second array did not identify anyone. I would like to point out that there's not a hole in the record, but there's only evidence that the officer showed the second array to 6 of the 10 victims. And there's no reason given why he did not show them to the other 4, but we only have evidence that he showed them to 6, and 4 made no ID, and 2 made IDs and said that they were 8 out of 10. Sure. Gary also, when he testified, said that he told the police officer that he was 10 out of 10. And that contradicted the detective's testimony that he had told him 8 out of 10. The defendant did not testify at trial, I'm 100% sure. He said he had told the detective that he was 100% sure. All of this was exploited by defense counsel and brought up in his closing and through his cross. So I don't think there was any issue that did not get fully aired, that the jury did not have a complete understanding of how they were to judge the eyewitness evidence provided by the Commonwealth. I don't think the lack of the the four instructions would have made any difference in this case whatsoever, regardless of whether you view it from an ineffective assistance of counsel standpoint or from a substantial risk of a miscarriage of justice standpoint.
All right, thank you.
Counsel.
Thank you very much.
And we'll take our morning break.